This case presents a serious question concerning the meaning and application of that provision of the Fifth Amendment to the Constitution, which declares that no person shall be subject for the same offense to be twice put in jeopardy of life or limb. The petitioner, Robert Brown, was indicted by a grand jury on 2 counts. The first charged that he had committed arson by maliciously setting fire to a house. The second accused him of causing the death of a woman by the alleged arson, which, if true, amounted to murder in the first degree, punishable by death. Brown entered a plea of not guilty to both counts, and the case was tried by a jury. After each side had presented its evidence, the trial judge instructed the jury that it could find Brown guilty of arson under the first count and of either first-degree murder or second-degree murder under the second count. The trial judge treated second-degree murder, which is defined by the code as the killing of another with malice aforethought, and is punishable by imprisonment for a term of years or for life, as an offense included within the language charging first-degree murder in the second count of the indictment. The jury found Brown guilty of arson and of second-degree murder, but did not find him guilty on the charge of murder in the first degree. Its verdict was on that charge. The trial judge accepted the verdict, entered the proper judgments, and dismissed the jury. Brown was sentenced to 1 to 3 years imprisonment for arson and 5 to 20 years imprisonment for murder in the second degree. He appealed the conviction of second-degree murder. The Court of Appeals reversed that conviction because it was not supported by evidence and remanded the case for a new trial. On remand, Brown was tried again for first-degree murder under the original indictment. At the outset of this second trial, he raised the defense of former jeopardy, but the court overruled his plea. This time, a new jury found him guilty of first-degree murder, and he was given the mandatory death sentence. Again, he appealed. The Court of Appeals rejected his defense of former jeopardy and affirmed the conviction. 1 judge concurred in the result, and 3 judges dissented, expressing the view that Brown had twice been placed in jeopardy in violation of the Constitution. We granted certiorari. Although Brown raises a number of other contentions here, we find it necessary to consider only his claim of former jeopardy. The constitutional prohibition against double jeopardy was designed to protect an individual from being subjected to the hazards of trial and possible conviction more than once for an alleged offense. The underlying idea, one that he is deeply ingrained in the American system of law, is that the state, with all its power, should not be allowed to make repeated attempts to convict an individual for an alleged offense, thereby subjecting him to expense and compelling him to live in a continuing state of anxiety, as well as enhancing the possibility that even though innocent, he may be found guilty. In accordance with this philosophy, it has long been settled under the Fifth Amendment that a verdict of acquittal is final, ending a defendant's jeopardy, and even when not followed by any judgment, is a bar to a subsequent prosecution for the same offense. Thus, it is one of the elemental principles of our criminal law that the government cannot secure a new trial by means of an appeal, even though an acquittal may appear to be erroneous. Moreover, it is not even essential that a verdict of guilty or innocence be returned for a defendant to have once been placed in jeopardy so as to bar a second trial on the same charge. This court, as well as most others, has taken the position that a defendant is placed in jeopardy once he is put on trial before a jury, so that if the jury is discharged without his consent, he cannot be tried again. This prevents a prosecutor or judge from subjecting a defendant to a second prosecution by discontinuing the trial when it appears
That's good.
Here, so what? The light. Hey, what? The light turn.